Many thanks for staying with us. When I head back to the courts, where we understand that an appeal court sitting in Port Harcourt has directed all parties involved in the appeal filed by members of the River State House of Assembly loyal to Federal Capital Territory Minister Nyesom Wike to maintain status quo pending the hearing of the substantive suit. The 27 pro-Wike lawmakers, led by Martins Amaewhule, had defected from the People's Democratic Party to the All Progressives Congress. They had gone to the courts to stop moves to declare their seats vacant. The three-man panel of the appeal court, which sat virtually on Friday, adjourned the hearing of the substantive matter to June 20, 2024. To discuss this, we're joined by human rights lawyer Ekine Henry. Thank you so much for joining us.
Thank you so much for having me.
So the Federal High Court in Abuja ordered all parties to maintain status quo in River State. What do you make of the ruling in light of how heated up the state has been in the last few months?
I think apparently it's a continuation of an appeal that is pending before the Court of Appeal in Port Harcourt. It is actually expected to calm concerns about those who were expecting an end to that appeal today. But the reality here is that it has actually elicited some reactions by different persons and expressing different understanding of what the orders and the positions that the court have directed today, really. But I think in all, what's important is that the Court of Appeal has adjourned to the 20th of June, 2024 for hearing of the appeal. For those who would understand, it would mean that the appeal proper hasn't been heard, except that there are probably preliminary issues that the courts had to consider, and then hear and determine certain motions that had to be taken before the hearing of the main appeal.
Okay, so let's look at it from this angle. Now, Martins Amaewhule, on behalf of 26 others, challenged the decision of the River State High Court, which actually vacated their seats and restrained them from sitting or carrying out any legislative functions. Then what's your disposition to legal moves like this when the Constitution is clear on matters of political party defection?
Well, apparently this has been the burning issue in River State since the 11th of December 2023, when on plenary on the floor of the River State House of Assembly in the proceedings of that day, 27 lawmakers indicated and expressed their fundamental right to belong to association or cease to belong to any association, and declared formally that they were no longer members of the People's Democratic Party that sponsored them to that house. And this was clearly made known by the presiding officer, who himself is Honorable Martins Amaewhule, who presided on that day, the 11th day of December 23 rather. And he said publicly as proceedings of that day, which ought to be taken judicial notice of, that all those members had voluntarily withdrawn their membership of the People's Democratic Party and had defected to the All Progressives Congress. And he actually decided, and of course that was understandable, to read out the letter of the Deputy Speaker. It's understandable because that's the second of the ranking in the House, and read completely that. So since then, since that 11th of December, there have been reactions pursuant to the provision of the Constitution, Section 109, subsection 1, paragraph G, which is extant and then very clear, very direct, unambiguous. And Nigerian citizens, especially those in River State, have ensured that we promote the observance and, of course, uphold the provisions of the Constitution. It doesn't matter who was involved. So that matter had gone on. There are a lot of litigations in different courts, at the High Court of River State and the Federal High Court in Port Harcourt and elsewhere. So the last of it, that probably is the foundation to this appeal at the Court of Appeal, is the one that Right Honorable Victor Okojumbo and others approached the High Court of River State, presided over by Honorable Justice Nyesom Wike. Okay. And then that matter too is subsisting in that High Court, but there was an interlocutory application that the courts heard and determined and made some interlocutory orders and interlocutory injunction restraining Martins Amaewhule and 26 others from parading themselves as members of the River State House of Assembly and engaging in legislative functions. So that was the basis for the appeal at the Court of Appeal.
Okay, so let's just, in a very few seconds, wind back a bit. And I'd like to put this question. Is it constitutionally right now to claim that neither President Bola Tinubu nor Governor Fubara has the statutory powers to stop the Independent National Electoral Commission from conducting fresh election to replace these 27 Rivers State lawmakers that defected based on the agreement that was initially reached?
Now, apparently, the Independent National Electoral Commission is a creation of law. Section 153 of the Constitution of the Federal Republic of Nigeria established that commission. And then moving forward, the Constitution showed that that commission is independent, meaning that no individual, no authority shall interfere with the performance of the functions of that commission, including directing the commission one way or the other, or restraining the commission from performing its function except by an order of court. So Mr. President is not above the Constitution. So Mr. President or the Minister of the Federal Capital Territory or any individual cannot under any guise, except otherwise, except we have decided to jettison the rule of law and then which we profess to actually uphold. That's the only point that you could lean on any purported agreement or any other designation of any sort to seek to restrain the Independent National Electoral Commission to conduct elections. So, and I think very important, that the Independent National Electoral Commission has a statutory and constitutional duty to conduct election where there are vacant positions in any legislative house. And that indeed is what they got to do. It's a public duty they need to perform.
Okay, so now that we've been able to establish that once a lawmaker or politician defects from a party, most especially in the legislative house to another party, that seat will be declared vacant because that was not the party or the seats that actually brought him, that's not the party that actually brought him into power. So finally, what might eventually play out in Rivers State as power tussle revolving the governor of the state, Fubara, the FCT minister, their loyalists continue to linger, and of course, what the court ruling will be. What should we expect?
Well, it's unfortunate. It's been an unavoidable experience that we have had here in Rivers State, unnecessary skirmish that I think I imagine that we shouldn't have had, but unfortunately is here. So, but I make clear positions, constitutional positions. The governor of a state has constitutional functions to perform, and then there are exclusive functions. So you would not imagine that the governor of a state will have any problem with the minister of the Federal Republic of Nigeria with respect to the performance or the functions of the governor pursuant to the provisions of the Constitution. So to that extent, whatever difference that the minister would have with the governor shouldn't be in relation to the performance of the functions of the governor with the provisions of the Constitution. That would be an aberration to constitutional democracy. Then again, the crisis have actually had the negative effect in the state. We thank God that we still are able to have some level of peace in this country, in this state, and then that the governor is going on with administration. Apparently, we have the problem more in the legislature, that is the House of Assembly, more than in the executive, because the governor is performing the executive functions. He has his cabinet constituted, he has his aides, and then he's going on with the functions of state. But it is in the legislature that we have had much of the problem, where these 27 former lawmakers deliberately, willingly, without prompting, decided to abandon the political party that sponsored them to office. And recall that to qualify to run election to the House of Assembly, one of the qualifications is that you must be sponsored by a political party. And so when you get into office, you have to stay there. And we have cured that mischief that we had before the first alteration in 2010. When we had the alteration in 2010, the alteration of the Constitution, I think that could be the right alteration, that we made these provisions that you do not, and you cannot on your own willingly defect and then think that you should hold on to that position.
Hold on to the seat. Ekine Henry, human rights lawyer, thank you so much for shedding so much light on this. We appreciate your contribution.
Thank you very much for having me.